Prince, all stand and remain standing until the conclusion of the reading of the proclamation. Ladies and gentlemen, the proclamation. All persons having any business before this honorable court now draw nigh. Give your attendance, and you shall be heard.
A ceremonial sitting of the Supreme Court of New South Wales to mark the occasion of the retirement of the Honourable Justice Beech-Jones, Chief Judge at Common Law and Judge of Appeal, upon his honours appointment as a Judge of the High Court of Australia.
I begin by acknowledging the Gadigal of the Eora Nation and pay my sincere respects to Elders past and present, and extend those respects on my own behalf and on behalf of the Court to all Aboriginal and Torres Strait Islander people. This ceremonial sitting of the Court is bittersweet. On the one hand, we lose the services and day-to-day company of a very fine and most respected judge, and someone whose brief but brilliant leadership of the Common Law Division has made a huge contribution to the general flourishing of the Supreme Court of New South Wales. On the other hand, we celebrate Justice Beech-Jones's appointment to the High Court of Australia as the 57th Justice of that court. There was a compelling case for the appointment to the country's apex court of a Supreme Court judge, and one with deep experience in the criminal law. There was an equally compelling case for that judge to be Robert Beech-Jones. Although much has been made of His Honour's expertise and experience in criminal law as a particular reason why his appointment has been so timely and well received, that should not obscure the fact that he is also a very fine public and constitutional lawyer, with his interest in those areas of the law stoked by his undergraduate studies at the Australian National University under the late Professor Leslie Zines AO and other distinguished members of that faculty in the 1980s. At the ANU, he was awarded the Commonwealth Constitutional Law Prize as well as the Evidence Prize, harbingers of things to come. Earlier this year, His Honour delivered the 15th Whitmore Lecture on the topic of the Constitution and State Tribunals, and he has been a participant in the biennial Zines symposiums organised by Professor Stelios and Acting Justice of Appeal Griffiths. As a Tasmanian constitutional lawyer, Justice Beech-Jones's appointment perhaps also corrects an historical wrong, namely the passing over of Andrew Inglis Clark for a seat on the first High Court in 1903. Indeed, His Honour has recently described Inglis Clark as the polymath's polymath. It must be observed that Justice Beech-Jones has long held a candle for Tasmania, including in his well-known dissent in Zarafa in 2013, where in a masterly survey of Australian case law on an important question of federal sentencing, he memorably began a short paragraph with the sentence, quote, "Tasmania is too often overlooked," unquote. He then noted that there were no relevant Tasmanian decisions on point. In all seriousness, His Honour's dissenting judgment in that case was a superb piece of judicial analysis and was vindicated last year in the Court of Criminal Appeal in Totan, where his dissenting position became a majority position since picked up throughout the country. His judgment was described as containing, quote, a powerful analysis and, quote, compelling reasons, which was very kind of me. and I trust won't be forgotten. Returning to the ANU, His Honour was also awarded the A. Antilliard Prize for Outstanding Contribution to University Life. If there were a similar prize for outstanding contribution to the Supreme Court of New South Wales, he would be awarded that also, although he would much prefer a Brownlow medal, but that would be delusional. As a solicitor at the bar and on the bench, His Honour has been a true all-rounder, another reason why his elevation to the High Court is so timely and well warranted. In these remarks, I will focus on his career on the bench, but the breadth of his experience as a solicitor and barrister should not be overlooked. As a solicitor, he spent 2 years at Freehills, but then, interestingly and importantly, 2 years at Craddock, Murray and Newman, practising in crime and migration law. At the bar, he did everything, including long and important regulatory cases for ASIC against directors and or officers of GIO Insurance and James Hardy, as well as being one of the counsel assisting in the HIH Royal Commission. These were all challenging briefs against the cream of the commercial bar. He also practised in white-collar crime and administrative law, notable cases including representing Guantanamo Bay detainee Mamdouh Habib against the federal government and Christina Rich against Price Waterhouse in one of the then largest and probably still largest sexual harassment cases in Australian legal history. Appointed with a full head of hair to the Supreme Court on the 12th of March 2012 at the tender age of 47, Justice Beech-Jones sat in the Common Law Division until late 2021 when he was elevated to the important position of Chief Judge at Common Law and also as a Judge of Appeal. While he has continued to hear matters at first instance since that time, he has presided regularly on the Court of Criminal Appeal and sat on the Court of Appeal, delivering many judgments of note to which I shall return. As a heavy lifter in the Common Law Division, His Honour conducted many criminal trials, including the trial and sentencing in a 6-month tax fraud in the case of Dixon, the trial and sentencing for murder in a case involving extreme domestic violence in the case of Maglovsky, the trial and sentencing in relation to charges of corruption in Obeid, a judge-alone trial and sentencing for murder in Quinn, another murder case involving cold case disappearance of a 13-year-old girl in 1998, the case of Tarantino, the trial and sentencing on a murder charge but resulting in manslaughter conviction involving the killing of an elderly mother in Eckersley, I think during a cold Goulburn winter. Officer A, the trial of a correctional officer where there was a hung jury, and most recently the sentencing for manslaughter in one of the gay hate cold cases of White. This is a small selection, but even this collection of cases involved innumerable interlocutory and evidentiary rulings, voir dires, and complex directions to juries. His Honour's deep knowledge of the anatomy of a criminal trial, not only in terms of substantive principle, but his mastery of criminal procedure and sentencing principles at both trial and appellate level, will inform and underpin his judgments on the High Court in a way that will ultimately be of immense value to that court and to the profession whose confidence and respect he already commands. On the Court of Criminal Appeal, His Honour has sat on more than 350 appeals, with significant decisions including Marwad, which is one of the most cited judgments in the bail jurisdiction, Hamilton, where His Honour's decision was upheld by a majority in the High Court in relation to anti-tendency directions, AK, concerning the concept of a miscarriage of justice, Sharma, concerning aggregate sentencing, MK and RB, dealing with resolving a conflict of lines of authority in relation to the offence of persistent sexual abuse of a child, and Z in a joint judgment but involving an important discussion of DNA evidence. There's also been a multitude of CCA sentence appeals in which His Honour has discussed a variety of aspects of resentencing in accordance with the High Court's decision in Kentwell. On the civil side, His Honour's time on the Supreme Court has been equally demanding and equally productive. He spent 10 months hearing evidence and submissions in the massive Queensland floods class action, one of the longest class action trials to run in Australia and the longest in this court. He also managed the Lamb and Rolls-Royce litigation, in which around 500 passengers on the Qantas 380 sued for psychiatric injury after the Rolls-Royce engines failed, although disaster was averted. The case ultimately settled. More recently, he approved the settlement in Ellis and the Commonwealth, a class action involving members of the stolen generation in the Northern Territory. Another excellent example of His Honour's industry and extraordinary work ethic was his decision in Kazam and Hazard. That case involved an extensive challenge to the various COVID-19 health regulations. Proceedings were filed at the beginning of September 2021. The matter was listed for final hearing within the month, with a hearing including extensive evidence and submissions taking place over 4 days between 30 September and 6 October. A comprehensive final judgment was delivered 9 days later. The decision was upheld by the Court of Appeal a matter of weeks after that. Although most of his appellate work took place on the Court of Criminal Appeal, Justice Beech-Jones has also delivered significant decisions on the Court of Appeal which further demonstrate the breadth of his range and legal ability. They include the Attorney General and FJG, considering the sensitive and difficult question whether the Registrar of Births, Deaths and Marriages was empowered to, quote, correct an entry in the register in circumstances where one party to a marriage later changed their legal sex. Another case, the Next Generation, considering the scope regulation making power under the Protection of the Environment Operations Act. A case called Osbao, considering whether compensation could be ordered from the Torrens Assurance Fund for an inaccuracy on deposited plans. A case called Shepherd and Smith, involving a valuable distillation of principle on the abandonment and obsolescence of easements, a topic which His Honour hopes never to return. And relatively recently, a case Amica and the late Fortunato Frank Gatt, in relation to complex questions of causation in the dust diseases context and epidemiological evidence of lung cancer, where His Honour's very fine scientific brain was engaged. The dutiful recitation of even a small body of His Honour's work does not do justice to his great industry and commitment to the work of the court. It does, however, place importantly on the public record some of his most significant decisions and illustrates the great breadth and depth of His Honour's learning. For much of his time as a judge on this court, His Honour also served on the executive and was ultimately president between 2016 and 2018 of the Judicial Conference of Australia, now the Australian Judicial Officers Association. This was not only valuable work, but gave him an early lens into the whole of this country's judiciary, from which original jurisdiction apart, the High Court's work originates. Also to be acknowledged and indeed highlighted is Justice Beech-Jones's great contribution to this court as Chief Judge of the Common Law Division. That is no small or undemanding job. The division is large and the range of its work wide, from administrative law, possession, personal injury, professional negligence, defamation and institutional abuse on the civil side, as well, of course, of the whole of the court's criminal jurisdiction, including bails, high-risk offenders, which is a huge new area of the court's work, federal criminal jurisdiction with all its complexities, and the Court of Criminal Appeal, on top of the steady diet of murder, manslaughter, terrorism, and serious fraud trials. Also, under the immediate supervision of the Chief Judge at Common Law is responsibility for surveillance device and warrant authorisations, as well as overseeing the court's response to proposed legislative and law reform initiatives in relation to our criminal justice system. To manage this division requires great skill, knowledge, close attention to detail, and enormous energy. It also requires intellectual leadership and a high degree of EQ, which is different from and not an abbreviation for equity. On every count, Justice Beech-Jones's tenure as Chief Judge has been quite outstanding. On a personal level, he and I have had a great deal to do with each other, particularly since my appointment as Chief Justice 18 months ago, and I have greatly valued his advice, counsel, experience, humanity, and shrewd and measured judgment. He is a very fine man who has become, I trust, a good friend as well as a close professional colleague. He has my deep respect and admiration. That having been said, in the robust tradition of the New South Wales Bar, in which we both grew up and which some say carries through to its judiciary, candour requires me to observe that with His Honour's appointment, the sartorial standards of the High Court are likely to plummet. His famous ink-stained CCA robes, which rather resemble Jackson Pollock's smock, will soon be repossessed and may well adorn a mannequin for the purposes of our forthcoming bicentennial celebrations next year. In memory of His Honour's boyhood home, the mannequin might come to be known as the Savage from Savage River. Savage River was also the name of a 2022 ABC drama series. 3 observations may be made in that regard. First, the series was not about His Honour. Secondly, it was not written by Susie Miller, thereby putting it into a small category of recent Australian literary works. Third, one reviewer described the series as, quote, a gripping new take on the Australian Gothic, unquote, while the Guardian review described it as, quote, never terrible but never surprising either. Although His Honour is an avid reader of the Guardian, I have the utmost confidence that the reviews he receives at the end of his tenure on the High Court will be far, far better than that. Justice Beech-Jones, on behalf of all of the judges who are also your friends on the court, I thank you for your outstanding and exemplary service to the Supreme Court of New South Wales and offer you every best and sincere good wish for the important work that lies ahead of you. Mr. Attorney.
Thank you. Thank you very much, Your Honour. I acknowledge the traditional custodians of the land, the Gadigal of the Eora Nation, and I pay my respects to elders past, present and future. I acknowledge our Aboriginal colleagues and friends here this morning. Your Honour, on behalf of the Bar and the people of New South Wales, it's my very great pleasure to wish you well on your departure from your role as Justice of the Supreme Court of New South Wales, Chief Judge of the Common Law Division and a Judge of Appeal, and to make some brief comments. Today gives us a wonderful opportunity to briefly reflect on your significant contribution. Firstly, may I acknowledge the members of your family and thank them for sharing you with the people of New South Wales and soon the nation. Joining us today are your wife Susie and your children Gabriel and Sasha. I know you're honoured by the presence of many dear friends and colleagues today, with special mention to Associate Professor Sean Brennan and Associate Professor Karen O'Connell. And of course, there are some people who'd like to be here today who cannot. Your parents, Joan and Mike Beech-Jones, are proudly watching from Perth. Also watching are your 3 older brothers, David, Mark and Martin. Sadly missed today will be Susie's parents, the late Elaine and Rob Miller. People present today... Oh, sorry, my speechwriter's let me down already. I welcome your parents to the gallery today. Sadly missed today, as I said, will be Susie's parents, the late Elaine and Rob Miller. People present today and watching from afar have supported this address by providing an overwhelming number of remarks, memories and anecdotes, which I have truncated, of course. The words have given us a clear picture of your journey. Much has been said about your early life and how it has shaped you, Your Honour. Your parents emigrated from Wales in 1963 with your 3 older siblings. The wilderness of northwestern Tasmania is where they settled and where you were born. Your childhood years, as we've heard, were spent in the settlement of Savage River. You've said previously that the name of the town is the most exciting thing about it, or it was until the town's first and only Space Invaders machine arrived. Notwithstanding all of that, we've claimed you for New South Wales. And I know, however, that you will want to make it clear today that you are a very proud Tasmanian. Early life was pretty simple and uncomplicated. The wondrous and rugged nature of home was your playground. You loved cycling and camping by the creek. Footy was your winter sport. Cricket was the summer. You shared a deep bond with your brothers. Your relationship with your family was and is still very close. You were well liked at school, and I'm advised that your honours seem to be blessed with not having to study terribly hard. You always did well at your studies, and the words high achiever are frequently recurring. As we will discover, those words would be used many more times. Your start as a lawyer came at Freehale, Hollingdale and Page before moving to Craddock, Murray and Newman in 1990. After just 4 years as a solicitor, you were called to the New South Wales Bar in 1992. Your career as a barrister was spent at the 11th floor St James Hall. As a barrister, you appeared in a wide variety of legal proceedings, which reflects your view that a good barrister should have a wide breadth of experience. You practiced frequently in commercial law, regulatory enforcement, white-collar crime and administrative law. As we've heard, standout cases included as acting as counsel for Guantanamo Bay detainee Mamdouh Habib and for Christina Rich in one of the largest sexual harassment cases in Australian history. You've performed the role of counsel assisting the Royal Commission into the collapse of HIH and acted as counsel assisting the Independent Commission Against Corruption. You took silk in 2006 and your contribution to your profession has been felt in and outside of the courtroom. You've served as a member of the New South Wales Bar Association's Human Rights Committee. You were also a member of the Bar Association's Professional Conduct Committee and led a large number of investigations. To encapsulate all of the comments we've received about your career as a solicitor, barrister and senior counsel, I can return to my previous description, high achiever. Colleagues highlight your intelligence, deep knowledge, drive, skill and personality. One solicitor we spoke to described you as having the most incisive mind of any barrister they've had the pleasure to brief. All remember many of your endearing qualities. You did things with a minimum of fuss, you were understated and there was not a hint of pomposity. What was always present was integrity, and I would like to add humanity. In his welcome to you to the Supreme Court of New South Wales in 2012, former Chief Justice Bathurst focused on your integrity and intellectual standing. He concluded that speech with the hope that you would have a long and fulfilling judicial career. That hope has come to pass, and you still thankfully have a long way to go. You've presided over more than 500 civil hearings and criminal trials. You've participated in around 375 appeals in the Court of Criminal Appeal, writing the leading judgments in many, and sat in on a further 40 appeals in the Court of Appeal. You've presided over some of the most significant cases heard in New South Wales on matters of high importance to the New South Wales community. Criminal matters such as the recent matter of the Crown against White in June of this year in relation to the manslaughter of Scott Johnson, person you described in your judgment as a brilliant mathematician and someone who had everything to live for. You also heard the application for a judge-alone trial in the Crown against Dawson last year, which received enormous coverage. In reviewing just a snapshot of the numerous judgments that you've delivered, I was struck by one thing in particular. As is reflected in the comments of your colleagues, Your Honour has a particular ability to not only deliver clear and comprehensive judgments that reflect your exceptional legal skill, but also bring humanity to your role. A word that is oft repeated about you is humanist. Your care to reflect on the impact to individuals in the matters over which you preside abides in your judgments. In matters involving distressing and challenging facts and circumstances, You have often paused to acknowledge the deep grief and suffering of people impacted, and you've recognised the emotional significance of the outcomes in many of the matters that you have considered. In 2021, as we've heard this morning, whilst New South Wales was still in the grip of the COVID-19 pandemic, you heard a challenge to certain public health orders. This case involved the consideration of multiple days of evidence, including expert evidence adduced to address a wide range of issues relevant to an unprecedented public emergency. It also attracted considerable community interest, with thousands of people watching live streams of the judgment and proceedings and hundreds of people emailing your chambers. Your management of these proceedings and delivery of a thorough, considered and comprehensive judgment in extraordinary and unprecedented circumstances exemplifies your career as a jurist and stands as an example of the best qualities and characteristics of our judiciary: independent, impartial, fair, and with your personal hallmark, a genuine empathy for those seeking justice before you. Importantly, it's said that you've never changed who you really are. You're still wonderfully unpretentious. It's said that you offer civility in every moment and expect it in return. Your fellow judges consider you to be a brilliant ally. You've been a fantastic leader of the Common Law Division. You've led with great skill and energy and contributed in a very real way to the high reputation and strong collegiality of the Supreme Court of New South Wales. Your colleagues offer that they are in awe of your beautifully written and well-reasoned judgments. Most were also awestruck at the last Christmas party, Your Honour, when you welcomed new judges and summed up the year by doing it in a rap. They also appreciate your very, very funny weekly roundup emails, taking the opportunity to highlight great work, offer advice, but mainly for you to poke fun and show your in-depth knowledge of pop culture. I'd like to take a very short moment to address a few comments that are offered by family, friends and colleagues for a bit of gentle fun. One of your brother judges suggested that your car could probably do with a clean. Perhaps it's first, inside and out. Another contributed by saying, Robert comes from Welsh mining stock via the west coast of Tasmania. It's extraordinary to think that he went anywhere when you think about it. I won't identify that gentleman, but suffice to say he does seem to be having quite some fun in his new role as a district court judge. The biggest chapter in your life, of course, is your family. You are devoted to them. They have always been your priority. You're a hands-on dad, whether it was footy coaching or taking time off to help them prepare for the HSC. You and Susie are a brilliant team. You have supported each other to achieve remarkable things, including raising two wonderful children. You met almost 30 years ago when you helped her argue a case. She thought you were going to be posh with your double-barrelled name. She's glad she was wrong, and I know you're quite content to be the second best writer in your house. Footy is still a huge passion, and it seems that your only flaw is to be a Carlton supporter, or some other people accuse you of being a fair weather Sydney Swans fan. You have an encyclopedic knowledge of AFL, and you can name every premiership winning team in history. You still love playing, and Susie remembers both you and Gabriel winning best and fairest for your respective teams. She adds that your knees are always wobbly after a game, but that never stops you. Your Honour, may I offer in conclusion that all consider that you are the perfect appointment to the High Court of Australia. Colleagues who contributed thoughts for this speech summed it up best when saying, there is not a single person who can cavil with your appointment, not one. In times of challenge, crisis or turmoil, our judiciary are often called on to make complex decisions on matters of significant community concern. You have done so time and again, never wavering in your commitment to the law, to fairness, to justice and to integrity. I know that you'll continue to do so in your new role, and our country will be all the better for it. And I know I speak today for not only the members of the Bar and the people of New South Wales, but for all here today when I say that we are sad for your leaving, gratified that we have been a part of this chapter of legal life in New South Wales with you, and proud and thankful that our state is able to yield up a judicial treasure to step up and enrich our nation. Your Honour, on behalf of the New South Wales Bar and the people of New South Wales, thank you for your service, and we wish you the very, very best wishes. May it please the Court.
Mr. McGrath, Senior Vice President of the Law Society of New South Wales.
May it please the Court, I too acknowledge the Gadigal of the Eora Nation, the traditional owners of the land on which this court stands, and pay my respects to elders past and present. I acknowledge and extend my respect to all Aboriginal people who are with us today. I would also like to acknowledge Your Honour's family who are with us today, your friends, and all distinguished guests. On behalf of the more than 40,000 solicitors of the state, it is a privilege to congratulate Your Honour on your work and immense contributions to the Supreme Court of New South Wales. The appointment of Your Honour to the High Court of Australia means that 4 of the High Court's 7 members come from the New South Wales Bar or Bench. Although Your Honour may balk slightly at that suggestion given, as we've heard, Your Honour is a proud Tasmanian. I believe that Your Honour has had to leave home at the age of 15 because there was no high school with years 11 or 12 in Savage River, where Your Honour grew up. And given the average number of rainy days in Savage River, Your Honour may have also had other motives. As has been widely noted, Your Honour showed a high degree of intelligence as a young man, and yet you have credited your older brother as paving the way for you and your siblings to consider higher learning. Nevertheless, there was a scholarship to study law and science at the Australian National University in Canberra, combining applied mathematics, computer science, physics, and law, and graduating with honours in 1988, plus 3 separate prizes which we've already heard about. In addition to all of this, there was also a self-professed love of arguing and debating. These are small marks in a wider world, perhaps, but they set the stage for a much larger life in the law. As has been remarked, Your Honour only spent 4 years as a solicitor. Using a footy analogy, as they say, a fast game must be a good game, Your Honour. But out of around 35 years of tireless work in the law. You were called to the bar in 1992 at the age of 27, which marked the beginning of a stellar career as a barrister. During this time, Your Honour also married Susie Miller and gained silk in 2006. Your Honour joined the New South Wales Supreme Court in March 2012. This is a short version of a much more colourful and outstanding legal career, but I do not wish to repeat what is already a matter of public record and said today. Before we continue, I note Your Honour has been quoted in the press a little while ago as saying that once upon a time you accepted that you would be, and I quote, a footnote in my wife's brilliant career. Your wife is, of course, the famous playwright. Ms. Miller has won numerous awards and enjoyed international success with her plays. She is also a successful lawyer. To add a little to the story we heard before, in relation to initially thinking that Your Honour's double-barrelled name was posh, Ms. Miller later learned that Your Honour's father was an only child. Also, that Your Honour's father was an only child. His mother sadly died from ovarian cancer when he was a child. To honour her memory, your father added his mother's maiden name to his surname. And this continues with you, as your love of your family is something that those who know you best consistently remark upon. Not surprisingly, that article also quotes Ms. Miller as saying she thought you would make a good High Court judge. Judging by our reason for being here, she has pretty good instincts. On the subject of family, Your Honour has publicly recalled that your maternal grandfather came from coal mining stock in the north of Wales. His name was John Griffiths, and Your Honour noted that he started work at the crushingly young age of 12. You remarked on the change in 3 generations of your family, how much opportunity you have had, and that your grandfather could only dream of. Well, today Your Honour leaves this court for the highest court in Australia, with a reputation for decency, humility, good humour, and with the utmost integrity. That sentiment is one that I've heard echoed throughout the profession that I represent, and while it may be mere opinion, it is one that is very widely and sincerely held. On the 12th of March 2012, in this same court, when Your Honour first joined this bench, the representative of the Law Society of New South Wales at the time remarked, Your Honour is known to be a prodigious worker, possessing a remarkable analytical mind, with a great insight into the underlying basis of legal principle. How true those words have proven since Your Honour has been on this bench. In 11 and a half years, Your Honour has produced 956 published judgments, averaging about 105 per year. This is an exhausting figure. Those hundreds of judgments have included many high-profile matters that we've heard, contentious trials, sentencings, and appeals. They have been either short or extremely long. At one extreme at the end of that spectrum is the Queensland Floods class action matter in 2019. It concerned the release of water from dams in Brisbane in January 2011 and the flooding of more than 22,000 homes and thousands of businesses as a result of rivers breaking their banks. The trial of this proceeding commenced in the Supreme Court of New South Wales on the 4th of December 2017. It concluded in March 2019. And on the 29th of November 2019, the Supreme Court of New South Wales delivered its judgment. There are 7 pages alone of cases cited in that judgment. It is a testament to the endurance for justice and Your Honour's dedicated attention to vast, complex matters. The high-profile matters have also included one of your most recent cases, the sentencing of Scott Philip White for the manslaughter of American mathematician Scott Johnson, as well as cases of convicted killers Matthew Quinn and Andrew Villaluna. It also includes the appeal for the Lynn family murderer, Robert Z., who has been sentenced to life in jail after 4 long and arduous trials for horrific crimes for 5 members of his family. Your Honour brought extensive criminal law experience from legal practice to this court, and in doing so paved an intelligent way through complex and difficult material, and as the Chief Justice noted, cited now throughout the country. I understand Your Honour found the Quinn case possibly the most emotionally difficult case you have dealt with in a long series of criminal matters. And yet your work in that judge-only trial was by all accounts compassionate, balanced, and focused. There was also the recent White case in which lengths were taken by Your Honour to ensure Mr White fully understood his plea of guilty for the manslaughter of Mr Johnson in 1988. The facts of that case were also extremely saddening. Mr White was allowed to have his solicitor sit beside him in the dock as he was arraigned, and Your Honour asked him directly if he understood that, and I quote, "You are accepting legal responsibility for Johnson's death, but not murder." Mr White replied, "Yeah, I do." Scott Johnson's brother, who has campaigned for many years to have the case heard, said this and the following sentencing was possibly the most emotional moment yet in the 34-year roller coaster that him and his family have had since learning of Scott's fate. "These have not been easy matters, Your Honour, but in these and others, Your Honour has held the reputation and conduct of the court to an impeccable standard. All these cases have been examples of what the legal profession reliably regard as Your Honour's authority in the area of criminal law. As the Chief Justice has written, this authority extends to constitutional law and administrative law. I would submit that this is partly because Your Honour possesses the ability to take complex factual and legal matters and make the reasoning understandable, not just to the legal audience, but to a wider audience in the community. To take complex ideas and break them down and express them concisely. To infuse them with a degree of humanity and persuasiveness. This has been a consistent quality in the vast quantity of Your Honour's judgments. Your Honour has also noted by the Chief Justice as having led the Common Law Division with great skill and energy, contributing in a very real way to the high reputation and strong collegiality of the Supreme Court of New South Wales. Your Honour has also shown a deep regard for community legal centres and access to justice. In a similar vein, a considered empathy for the many issues and lack of support for many Indigenous people appearing before the courts, especially in criminal matters. Nevertheless, in a speech in 2014 on proportionate justice, delivered to the Australian Lawyers Alliance, Your Honour opened by commenting that, I quote, "An appointment to the bench does not mean that you cease to be opinionated." You went on to say, "It just means that generally you should cease sprouting opinions in any public or semi-public forum. This is ironic because prior to being appointed, no one was particularly interested in letting me spout my opinions in any public or semi-public forum. The end result," you said, "is that the only people who ever hear what I think are my family and close friends, and they have either heard it all before or are either not interested in hearing it in the first place." Your Honour is also on record as ending a speech with this. "Where that leaves us is that instead of providing answers to the end of judgments, I pose questions at the end of speeches. Your Honour, I will not end with a question nor answers, but a statement. Your Honour will make a brilliant contribution to the High Court of Australia, although the legal community of New South Wales may in one sense be lesser for it, as the highest court in the Commonwealth gains in experience, perceptive and deep legal mind. The nation is better for it. On behalf of the Solicitors of New South Wales, I congratulate Your Honour on your outstanding service in the Supreme Court of New South Wales, as Chief Judge at Common Law and as a Judge of Appeal. I wish you all the very best in your appointment to the High Court of Australia, as the Court pleases."
Justice Beech-Jones.
Mr Attorney, Chief Justice, men and women of the judiciary and honoured guests, the traditional owners of the land on which this building is located are the Gadigal people of the Eora Nation. I also pay my respects to their elders, past, present and emerging, and all First Nations people attending. It has been an honour to be a judge of this court on Gadigal land. Chief Justice, Mr Attorney and Mr McGrath, thank you for your kind words. Mr McGrath, as the last to speak, you always have the toughest gig because the speakers in front of you, especially the Chief Justice, have a tendency to snaffle the best material. Thank you for your grace under pressure. Mr Attorney, please do not sack your chief speechwriter. I note that you've discontinued your new practice of naming the sources of your information, but I can guess where the source of the absence of my parents came from. Let's just anonymously call her Susie. And just say that there was a late change in plans. Thank you for placing on records the binding legal statement about my contributions at home. I'm confident that that person named Susie is not the source of that, because that may be seen as inconsistent with her previous representations on that topic. Generally, never has anyone been so fated for only doing 25% of the work. I'm honoured today by the presence of too many legal luminaries to expressly mention. I'll restrict myself to acknowledging the presence of the two distinguished and completely incomparable former High Court judges, the Honourable Michael Kirby, AC, CMG, and the Honourable Virginia Bell, AC. For any of you who do not know who they are, and I ask, how could that possibly be, they are sitting in the Valhalla section of the Banco Court to my immediate right. Which one of them is Thor and which one of them is Loki is a matter that I will leave you to judge. I also acknowledge the presence of my friends and soon-to-be colleagues, the Honourable Jacqueline Gleeson and the Honourable Jane Jago. If someone was to write a story about my career to this point, and let's be frank, why would they? Its title would sound like a Hobbit novel, namely A Tale of Five Chief Justices. I was admitted as a solicitor under the avuncular eye of Sir Lawrence Street, admitted as a barrister under the steely glare of Chief Justice Gleeson. I took my bows as a silk under the imperious watch of Chief Justice Spiegelman. I was sworn in as a judge under the shrewd gaze of Chief Justice Bathurst, and I depart under the sparkling observance of Chief Justice Bell. When you can reel off those five as the successive leaders of this court over 50 years, then you are a long way to understanding why this court has such an enviable reputation, both domestically and internationally. Of those five Chief Justices, I've worked closely with the last two, and of them I should say something more. It is fair to say that at times Chief Justice Bathurst and I had our differences. I suspect that my elevation to Chief Judge at common law during his time was very much the implementation of President Johnson's contribution to management theory, which I will paraphrase as being that it was better to have me inside the tent pointing out than outside the tent pointing in. However, I saw up close Chief Justice Bathurst deal with a pandemic, which was the gravest threat to the court's work in its 200-year history. No one should underestimate the size and scope of the job of Chief Justice, but the workload that Chief Justice Bathurst shouldered during the pandemic was immense, bordering on the intolerable. He very much deserves the state's gratitude for doing so. Almost 35 years ago at Government House in Canberra, I met a young law student with a sonorous voice wearing a tweed jacket. His name was Andrew Bell. He was quite something. We didn't have people like him in Tasmania then. They still don't. At the time, neither of us would have ever dreamed that decades later, we would be running such a busy and successful court together. However, I think I should rephrase that, as there was never really any doubt about what he would be doing. At the time, neither of us dreamed that 3 decades later, I would be helping him run such a busy and successful court. I leave a court that is led in every good sense of that term by its Chief Justice. The court is collegiate, its judges are productive, and its work is respected. The people of New South Wales can have confidence that their Supreme Court is in good hands. I've worked for, under and with 3 Chief Judges in equity: former Chief Judge Patricia Bergen, known far and wide as Paddy, Justice Ward, now President of the Court of Appeal, and my former employer, Chief Judge Hammerschlag. There is a stereotype of the equity judge as the quiet, demure, retiring type. I have to say that I'm yet to see that stereotype manifest itself in any of its Chief Judges. I'm grateful to those great judges and all the judges of the Equity Division for their support over the years. Beneath the finely polished hood of the F.J. Holden that is the Supreme Court lies a well-oiled engine that runs with grunt. The starting point to understanding why is the court's chief executive officer, or as I call him, the bureaucracy whisperer, Chris Daith. His exemplary low-key professionalism and patience in dealing with all threats, external and internal, including repeated flooding, has, along with the work of Rebel Kenner, enabled me to remain mostly sane since being appointed Chief Judge. There's also a point in the life cycle of a superstar when they lose their surname. Think Ronaldo, or better yet, Beyonce. Since time immemorial, that status has been conferred on the court's listing manager, Emilio Sesta Insani, whose wide fan base know him simply as Milio. He is the most important person in the court, bar none. I've spent years trying to understand how he does his job, and more importantly, when he does the job, but I'm none the wiser. While Milio is a person, he is also a concept. As a concept, Milio exemplifies the devotion of all the court staff who keep the court running, and they do so without the benefit of titles, red robes, or farewell ceremonies. I record my appreciation for his work and all the court staff, including those in the registry, the court and sheriff's offices, as well as the registrars and deputy registrars. The New South Wales Court of Appeal is the jewel in the crown of the New South Wales judicial system. The quality of its judges and the volume and quality of its judgments speak for themselves. As a trial judge, and then as a member of the Court of Appeal, nothing focused my mind more than the knowledge that another judge of appeal, and for example's sake, let's call them John, would soon be hunting down some loose thought that might be otherwise minding its own business, not harming anyone, in the judgment I was about to circulate or publish. I've been pen friends with the Court of Appeal for many years, writing to them as a trial judge and then as a colleague. I look forward to continuing our correspondence. Although from a slightly different perspective. Leaving aside their feedback, I thank the members of that court for their friendship and collegiality over the years. When I was appointed Chief Judge of the Common Law Division, it was received well, at least to my face. One person who did not feign exultation was my tireless associate, Margaret Gertner. She recognised immediately the extra work associated with that role, especially for her. I'm extremely grateful for her support and thank her for agreeing to work with me at the next stage. I extend my thanks to all the associates of the court. It is true, I declare, you do run the place. I've had 11 tip staff while a judge of the court, all of whom have been wonderful. I'm glad to say that the most recent of which, Natalie Cito, will also continue on. The yearly inflow of tip staff with new ideas and enthusiasm is a great resource for the court. A premise of this speech is the significance of the work of both arms of the profession to the proper running of the court. I do not wish to understate the assistance I've derived in other types of cases, but I feel compelled to record my appreciation for counsel who've appeared in the Court of Criminal Appeal and those who instruct them. Their professionalism enables that court to hear and determine more than 300 criminal appeals a year, a figure that comes close to the total sum of all other criminal appeals heard by intermediate courts of appeal across the country. As Chief Judge of the Division, I've liaised with the profession who have also been generous with their time. I would like to particularly thank the outgoing President of the Bar Association, Ms Gabby Bashir SC, and the Director of Public Prosecutions, Ms Sally Dowling SC, for their cooperation and assistance. As a judge of the Common Law Division, I've worked under two Chief Judges of Common Law, the Honourable Peter McClellan AMKC and the Honourable Clifton Hoban AMRFD. The contribution of Peter McClellan to the justice system and this country generally is a topic too large for a swearing out speech. It's probably best addressed via a 7-part mini-series. Can I state that he was the exemplar of the position of Chief Judge and a great source of advice when I assumed the role. Sadly, upon his departure, Cliff Hoban did not bequeath me any of his large collection of rugby ties, but he did hand over a division that consisted of 5 judges that I was privileged to serve, and that position is only strengthened by the appointments that have been made since. Although the descriptions of my leadership style have varied, I think it's best described as suburban third-grade football coach. Even so, all the judges of the division have been unfailingly supported. They are devoted to their roles and conscious of the important decisions they make. They decide cases of complexity, variety, and the utmost seriousness. The daily business of the Common Law Division is literally life, liberty, and if not the pursuit of happiness, then at least the avoidance of misery. It is vital work. A professional life spent as a judge of the Supreme Court of New South Wales is a professional life that has meaning. It has been a privilege to have been the Chief Judge of the Common Law Division of this great court. I'm honoured today by the presence of many friends and members of my family. I'm grateful to you all for your support and for doing your best to try and keep me grounded. Judges without grounding are really quite insufferable. According to my back of the beer coaster calculations, by about Christmas time this year, at least 1 million people worldwide will have seen or read something about the legal system written within my household, none of it written by me. By a logistical miracle, that author, my wife Susie, is present today, along with my extraordinary parents and my no doubt bemused children, Gabriel and Sasha. When I was sworn in as a judge, I recorded that as a son, father and husband, I've been loved and believed in. How privileged am I to be able to have them present 11 and a half years later, and for that statement to still hold true. I have sat through a lot of swearings in and swearings out. I could well understand the reasonable observer concluding that the purpose of these occasions is to remind the current generation of lawyers and judges that there was once a golden age of advocacy and judiciary, and that we risk losing that legacy if we all don't shape up. If that is said to be the point of these exercises, then, for the last time in this court at least, I dissent. I say that for those of you who are the future, these occasions allow you to select from the past what you will preserve, choose what you will reform, and decide what you will reject. I'll shock myself by paraphrasing another US president, this time Ronald Reagan of all people, and say that I firmly believe that the best days of the New South Wales Supreme Court are ahead of it and not behind it. I know that from observing the fine and increasingly diverse body of men and women who constitute the judges of the court and who practice as lawyers in the court. This speech is almost over, but there is still time for another AFL reference. We are deep in time on, and all that remains is for the siren to sound, hands to be shaken, and everyone to begin exaggerating how well they played. Thank you for honouring me with your attendance. RBJ out.
The court will now adjourn.
All stand. This honourable court is now adjourned.